Yes, I'll give it to the Honourable Jan Barham.
Thank you. There are times in this parliament where I've seen members work together in a genuine and positive way for the people of the state. A recent example was when the report of the Barham inquiry was presented and debated. And then there are times when matters are brought before the parliament that are misguided, misleading and outright wrong. The recent introduction of the Crown Lands Amendment Public Ownership of Beaches and Coastal Lands Bill by the Minister for Natural Resources, Land and Water, the Honourable Kevin Humphries MP, is one of these. The Minister stated in his second reading speech that the bill's introduction was prompted by the recent granting of a beach in freehold by the courts to a New South Wales Aboriginal Land Council. Legal experts and Aboriginal land councils regard that assertion as inaccurate and have suggested that the bill was unnecessary, unreasonable and potentially in violation of the Commonwealth Racial Discrimination Act. The Minister claimed that the prompt for this bill is an emerging risk of private ownership of beach land triggered by a recent court decision under the New South Wales Aboriginal Land Rights Act. He was referring to the decision of the Land Environment Court regarding a section of land at Red Rock near Coffs Harbour. But his characterisation of the decision was misleading to the Parliament and the public. Contrary to the Minister's claim that the judgment granted a beach in freehold, the Land Environment Court's judgment made clear the foreshore was not included in the land claim, that the Coffs Harbour and District Aboriginal Land Council and the Court were both of the view that the beach and any land necessary for access to it was not claimable, and that the provision of an easement was adequate to ensure public access in perpetuity. The interpretation of the judgment and the rejection of the need for the bill is made clear in responses to the bill from legal experts and stakeholders. On the 29th of October, Law Society CEO Michael Tidball wrote to the Minister on behalf of the Society's Indigenous Issues Committee, noting that the grant in this matter was made subject to an easement for public access, thereby protecting the public's right to access and use the beach in perpetuity. In a case note commentary and legislation digest prepared following the bill's withdrawal that has been submitted for publication, John Corkill OAM notes that the bill was unnecessary since the effect of the court's decision in the Red Rock case was to guarantee public access to the beach in perpetuity. These legal analyses were supported by the New South Wales Aboriginal Land Council and the network of local Aboriginal land councils who protested against the bill and marched to the gates of Parliament, where I was pleased to speak and assure them that the Greens opposed the bill and had called for the withdrawal. I can only characterise the purpose of the bill and of the Minister's comments as being the foundations of a scare campaign about public access to coastal land. Documents obtained under a call for papers moved by the Honourable Reverend Fred Nile show that if debate on the bill had proceeded, the government was prepared to push ahead with that scare campaign. The documents include House file notes, draft second reading speeches and a list of high-profile beach and coastal areas subject to unresolved land claims, and maps showing coastal land claims, all of which appear to have been crafted to suggest that the bill was needed to prevent loss of public access to beaches, despite the clarity of the Red Rock decision. This Parliament is about to rise and we are heading into an election campaign. The government has withdrawn this misleading and racially discriminatory Coastal Lands Bill, but Minister Humphries has suggested it will be brought back. The government's broader reforms on Crown lands and their disposal have been postponed until the next Parliament. Thankfully, at least, improvements to the Aboriginal Land Rights Act were recently passed following a truly consultative and cooperative process overseen by Minister Dominello. Through the election campaign and into the next term of Parliament, the debates about these issues, Crown lands, coastal protection, Aboriginal land claims and public enjoyment of the coast, need to be undertaken in honesty and good faith. I commend those who worked to force the withdrawal of a bad and misleading bill and hope we will not see the like of it again.